Well, good afternoon. Thank you very much indeed for coming along after lunch, and obviously feel free to close your eyes and relax gently, because I know the food here is excellent, the wines are really good, although you'll notice that you didn't have red wine because the carpets in there are so expensive and so old that they simply can't countenance anyone spilling a glass of Rioja on them. But anyway, I say thank you very much indeed for coming along this afternoon. And in the way of fortuity, I'm going to talk about outsourcing and Solvency II, which has really come into focus, albeit it wasn't planned this way, following the Scandi America judgment, because clearly, as I think Peter has mentioned previously, the cross-charging VAT grouping issues arise in a legal context as a result of outsourcing arrangements primarily. My background, I'm a partner in a London law firm and was previously general counsel for Odyssey Re in London. It says in there Clausen Miller LLP, and today is my last day as a partner in that firm. I have a new badge on from Monday, so I couldn't quite cross that out on my slides, however. But today we're going to spend about 35 minutes just going through some of the outsourcing issues, touching on some of the things where the crossover with what Peter's spoken about previously. And in particular, I really want to drill down and look at some of the ways in which the Solvency II requirements and the Delegated Act requirements are going to make life a little bit more interesting compared to what they are today from a UK perspective. But first of all, if I could just ask, and this is the only participation from the audience I'm going to take, so don't worry, you can, as I say, snooze from now on. Could you put your hand up if you're from an insurance company, please? Could you put your hand up if you're from an intermediary? Okay, thank you very much indeed, because that just gives me a sense of where to pitch some of these issues. So, see here, just going to give a quick overview about how we've got to where we are. Look at the UK requirements, and I apologise to those of you who are from any other jurisdictions, but a number of those do flow through from some of the original directives. Have a look at what the Solvency II Directive and implementing acts say, and also what EIOPA has said recently, and just really touch on the end about things you should think about when you're going back and considering, well, how do these outsourcing arrangements cross over and how do my tax arrangements fit in with these? So at the moment, where are we now? I'm 52 years old, and I certainly remember probably about 10 years ago doing an article and getting ready, actually, my last in-house role for Solvency II and its arrival. Now, I've moved into a different decade, so it gives you an idea about how long it is we've been waiting for this to arrive. However, as you can see from there, originally 2012 was the implementation date, but as we all now know, as a result of having to change various other directives, we've now pushed that back, so the firm start date is 1st of January 2016. And already you'll be moving through a number of phases in the UK, preparing for that with the PRA. However, as well as the main directive, beneath that is a whole raft of other technical implementing measures. So the EU Commission at the moment has drafted and sent out for approval delegated acts, and in the new regime where CEOPS became EIOPA and then was giving statutory responsibilities, EIOPA is also busy preparing technical standards. So finally, and after the 18 months of waiting for the draft of the delegated acts, we now at least everyone can now see a lot of the granular detail around the directive, whereas before we were in this strange grey world of some people having seen it, some people not having seen it, some insurers being able to prepare on the basis of what they had seen in early drafts. Now at least it's a level playing field. Final bullet there, EIOPA also has issued some guidelines relatively recently about how to apply some of these measures in advance of them coming into effect. So we have a sort of range, as it were, of starting with the Solvency II Directive at the top, flowing down into different measures through to very, very granular detail about how to calculate the risk factors And when I'm reading these as a lawyer, I look at some of the mathematical calculations and my eyes pop out on stalks because I've no idea how you manage to deal with those. So we have a number of different things all coming together, hopefully in time for takeoff on 1st of January 2016. There are copies of the slides on the side as well, and I think that they're in your booklets as well. So, okay. So at the moment, for any UK authorised insurer and effectively for any branch as well, the guidebook, the handbook, the PRA tells us that we have to do a number of things in relation to outsourcing arrangements. And from having lived through the transition into the old regime in the UK when the FSA was created, at that time there was no interest at all in outsourcing. This was in N2 was 99, I think. It was not really particularly anything that was on the regulator's radar, whether at a national level or at a European level. However, clearly now, and particularly in CISC 13.9, which is the reference to the PRA handbook, both at a European and at a national level, regulators are extremely concerned about the effects that can be caused to insurers when you effectively push out significant parts of insurer activities to third parties. From a lawyer's point of view, the phrase is you can delegate the action, but you can't delegate the responsibility. So when the directive tells you have to do things, and when the FISMA 2000, the UK legislation, says you have to do things, those obligations remain yours as the insurer or the intermediary in certain circumstances, even though you may have given the operational responsibility away to someone else to actually do them. So hence, I think the recent concentration on a lot of detail around what you have to do to be compliant. So I've listed on this slide, and I'll go into a little bit more detail on a couple of them, but briefly. In the UK, you have to tell your regulator in advance if you're entering into a material outsourcing. Lovely word, material. Lawyers hate it because no one can tell you what material means. Regulators love it because it means they can catch anything at all. If in doubt, tell the PRA what you're going to do. So if you're going to do a large claims outsourcing, and I'll come on to, when I look at the delegated acts, more detail about some others. If you're going to delegate to a third party anything that you think is really important to the operation of your business, tell the PRA. It's the simplest thing to do. Interestingly, there's an express warning that says intra-group arrangements have to be viewed in exactly the same way as any external outsourcings. And I certainly know from my days in-house, we certainly viewed something that was done by another of our group companies in a more informal sort of way. Well, we know the people in Dublin, or we know the guy in France. Maybe we just don't need to bother quite as much with having a detailed agreement with them because we just cross-charge them every 6 months and it's all fine. We all know what we're doing. We're all part of the same family. So in the UK, the PRA doesn't see it like that. If you've got an intra-group arrangement, to them it's the same sort of systemic risk if there's a failure, because clearly part of your group might fail, resulting in a detriment to the UK authorised insurer. And this applies just equally to what I've just said about internal outsourcings. Before you sign up with your contract, you have to do an analysis, you have to do some due diligence on the third party, you have to think about transitioning over to the third party, and you have to think about the operational risk, because in the bigger bucket of your internal model, this falls within the operational risk category. Failure of an outsource is clearly an operational risk. So those are the things that the PRA expects you to consider in advance. They then go into quite a lot of detail about things you actually ought to have in your outsourcing, you should have in your outsourcing agreement. Very keen on making sure you look at any guarantees or indemnities from the other party. Do they have a parent company that would guarantee the performance? Very keen on making sure that you, the insurer, have a right of access directly to the outsourcer and that they answer questions, that you have a right to insist that they answer questions to the regulator and allow access to the outsourcer's premises as well, which certainly when I was drafting recently, I was asked to do a Solvency II compliant outsourcing agreement for a company that was asking a firm of actuaries to do some significant work for them. And I told them it was a material outsourcing arrangement and included in the draft a sort of term that said, the regulators can, you agree that the regulators can come and have any access to your premises at any time and you'll answer the questions. Now, of course, to a bunch of actuaries, and I apologise to you, this is not the sort of thing to which they're usually subjected. So I think they were a little nervous about the thought of having the PRA turning up in their offices down in the West End and demanding answers. But nonetheless, this is what you'll be expected to have in your agreements. Measures for performance management, if they're appropriate. Clearly, there's a quantitative difference between outsourcing your motor claims handling to a third party where you're going to have tens of thousands of claims every month. You clearly there need to be able to manage response times, service level agreements, and contrast that with outsourcing an actuarial function. It's how on earth do you manage how do you set a KPI for an actuary carrying out a review? So clearly performance management matters, but it has to be tailored to the appropriate arrangement. Business continuity planning, very, very important. As I mentioned before, this is viewed through the prism of operational risk. So what actually is going to happen in the event of a failure of the third party? Who's going to be able to take on? Is there data that they need to take on? Can you get at that data to transfer it to another third party? Can you bring it back in-house? So you need to think about this. And as I've gone through these, I hope actually you get the sense that a lot of this is fairly common sense as well. It's sorts of things that as a responsible business you should actually be thinking about when you're giving away an important function to a third party. But I think everyone has a slight feeling that, well, we don't really like to be told what to do by the regulators. But at least in this area, at least I can tell you that they've brought together what I would consider as a lawyer to be the kind of advice I'd be giving clients. Make sure you include all these key terms. And the bottom bullet really I suppose, is hopefully an idea about why this is a really good idea, apart from the operational reasons, which of course this will feed through into your internal models. So actually, this might have an effect. Someone from one of my clients took me through it in great detail, and I have to confess I did not understand a word of what they were saying about how the operational risk factors feed through, but I was certainly told that. So finally, when the Directive 2009 emerged, Article 49 tells you outsourcing of critically important functions should not undermine and this is a summary, undermine the governance or, and I apologise for the misprint, service to policyholders, increase operational risk nor affect regulators' ability to regulate. That's the big overriding principle for any arrangements. Now, I've already mentioned the implementing technical acts have come along and fill in that granularity, but that's the high-level requirement that you're meant to meet. Article 50 tells AOPA what it has to do, and interestingly also says specific consideration to be given to outsourcers and it uses the phrase third countries. Because here we're in a sort of intersection of jurisdictions where, of course, in a large multinational group, you may be using counterparty companies as part of your group within the EU, or they may be elsewhere in the world. And clearly that gives rise to a whole host of other issues about data protection and safe harbours, etc. But interestingly, as I say, the directive has said that the Commission, etc., should give consideration to third country outsourcing. But so far that really hasn't sort of emerged on the radar very much, even in all the mass of detail which has come out. And I've tried to find out what it is the Commission was thinking about this, and also what the PRA is sort of thinking has to be done around this, but so far without too much success. So if you have any insights into that, I would I would be very grateful. So as part of the planning, CEOPS, AOPA, gave advice on the implementing measures back in 2009. So we got an early sight 5 years ago now, a sight of what CEOPS' thinking was around the details about outsourcing arrangements, and which have found their way into the Delegated Act, which was finally published last month, and where the outsourcing requirements are contained in primarily in Article 274. So generally speaking, they're fairly similar to what's in the PRA handbook at the moment. And I've fudged it, of course, by using the word generally, and lawyers really hate that word as well. There is, however, quite some more granularity, some more detail in the EU measure than in the handbook, which is quite unusual. Usually it's the UK regulator telling everyone what to do in great detail. And in particular, a couple of sort of extra layovers on the Delegated Act that aren't really explicit in the PRA. And one of them is in relation to what is actually the UK's favourite, conflicts of interest. The FSA, the PRA, the FCA have a visceral dislike and mistrust of conflicts of interest within the insurance industry. So those of you who have got binders, those of you who deal with third parties that both underwrite and handle claims on your behalf, those of you who are intermediaries have been subject to a series of admonishments from the regulator about how it's dreadful these conflicts of interest exist within the insurance industry. The Delegated Act talks about a specific requirement to ensure that conflicts do not adversely affect the outsourcing arrangement. So again, you're going to have to think about that. Well, who is it that's actually doing this on our behalf? What else is it that they do for us? And is there any sort of pull in different directions between those two? And also, there's a specific requirement in the Delegated Act that the outsourcing arrangement is basically communicated to they don't use the word board, but that's what it is, the Board of Directors in the UK, and also authorised by the board. There you've got an explicit instruction that if you're doing something that's going to be critical or important, and I'll talk about that in a moment, in the outsourcing world, you're going to have to actually take it to the main board and have it approved. Now that may or may not be the case now in your governance arrangements, but certainly I know from my time in-house, the last thing that any board wanted to have on their agenda was, detail outsourcing arrangement for property claims from this binding authority. But nonetheless, as I mentioned before, some of these are quite sensible suggestions, and certainly where you're doing something that's critical or important, then that would seem to be a sensible suggestion. But your board of directors already have pretty full agendas as they are at the moment, so jostling for space with these is going to be quite interesting. In the last bullet, I mentioned about the guidance, the regulators and the guidelines for implementation. And we got told actually what is critical or important, which rather, I suppose, unsurprisingly is the outsourcing of a function without which the insurer could not deliver its services to policyholders. However, very helpfully, it then runs through a number of very specific examples. So, the design and pricing of any policy products, investment, portfolio investment, claims handling, data storage, and also if you buy in externally services, and this is where, interestingly, probably FiscalReps comes into play, provision of regular compliance, internal audit, accounting, risk management, or actuarial support. So when I go back to my example of outsourcing to actuaries under the PRA regime, that would be material. it would be critical or important under the new regime. And also, I think any outsourcing arrangement you have with Mike would also fall within that category. So I think here you get a sense that where we've moved in the market to quite a diffuse model of attempting to push out as many functions as possible outside the organisations, these rules tell us actually we're going to have to keep a much closer eye on these than perhaps we have done previously. Now, I know that Peter obviously mentioned before about the effect of the Scandia America case and on the VAT groupings and how that might flow through. I certainly know that from my own experience in-house that the setting out of the cross-charging arrangements internally within groups was both an area that we never wanted to tackle very much, and that when we did tackle it was actually quite difficult. When you're attempting to negotiate with a counterparty that's actually within your own group, telling them, well, this is how we're going to allocate the cost, this is how we're going to deal with tax cross charges, for example, that may arise. Certainly it's the only time I've ever been sworn at by someone in Swedish, which was an interesting experience. So I think these arrangements have suddenly been brought into a lot more focus as a consequence of this judgment. And certainly I have had a couple of informal conversations with organisations that have said, actually we'd like you to have a quick look at our, and they may not call them outsourcing arrangements, but actually that's what they are. They may be intra-group divisions of responsibility arrangements. That was one. Framework management agreement. And also one or two that were with external third parties where, although the VAT issue in Scandia America may not be relevant, nonetheless there was an issue about the cross-charging of an allocation of the taxes. So I think it's actually quite important when you're looking at these arrangements, and also thinking about your own internal tax arrangements, to have a clear idea in your head about where do you want the responsibility for this to lie, who should bear the risk if there is a tax charge in another jurisdiction as a result of the arrangement, and just at least to address the issue head on. You may not get it right because, I mean, if Peter Hewitt doesn't know what the outcome of some of the outcomes from the Scandia judgment are going to be, I'm certainly certain that I couldn't predict them to you if I was drafting an agreement for you. But at least you can take some of the risk out of this by knowing where the allocations are going to sit. One of the key things that both the PRA and the AOPA things have highlighted, and in a couple of studies I looked at as part of a working group I was involved with a long time ago in Brussels, was the view that as an industry we weren't very good at thinking about what we were doing with the work we were parcelling up to other people. That we were perfectly happy for someone to come along and give us a tender that might have been quite cheap, and we quite liked the look of that, but we hadn't really done a lot of thinking about what was the organisation to which we were entrusting these responsibilities. And as I mentioned before at the outset, you can delegate the operation or the function, but you can't delegate the responsibility. That is always going to sit with you as the insurance company. So I think it's very important that you are seen, both for your own sakes and also to make sure that you keep your regulators happy, that you're seen when you're entering into discussions for these sorts of arrangements to have done some due diligence on the third party. And the other reason for doing that, and this is the one that is going to be quite fun to implement, one of the AOPA guidelines is it says that you, the insurer, have to ensure that outsourcing staff have to be verified to be qualified and reliable. Now, I don't know how you think you're going to work out whether someone's reliable or not within an individual within an organisation, because I certainly couldn't do it with some of my colleagues to work out in advance how reliable they are. But the flippant point highlights a serious one, which is we're into an era now where we're pushing responsibilities, we're pushing functions out, and the third parties to whom we're doing that, we've never historically taken a lot of interest in what their culture's like, what their financial solidity is like. We've done it in reinsurance, very good at that, always historically been good at that because that's a counterparty risk. Is our reinsurer going to pay up? Why shouldn't we do exactly the same things with the third parties to whom we're delegating these responsibilities? So, message to you today would be go away, have a look at the people that you're dealing with outsourcing, whether it is FiscalReps or whether it is actuaries or whether it is Capita or whoever's doing your claims handling. And don't get me started about my dog insurance claim. AXA, I hope you're not in here. You're in for trouble if you are. I'll have a private discussion with anyone about that. And I think my sort of final message to you, and we're just about on time, is I think in any of these sorts of arrangements, and also generally in relation to the sort of intersection between third-party responsibilities and significant tax issues, honestly, the best way is to have an open dialogue with your regulators about this, about some of these issues. My predecessor at my in-house role told me, never apologise, no matter how late you are. So we would miss deadlines by months and months and months, but we would never say sorry. That's absolutely fine, but at least tell them why you were late, why you're doing something, engage with them, because I know from having worked myself at Lloyd's of London, if you as regulated companies, and you all are in this room, if at least you're engaging with your regulator, you can understand the nuances of the relationship a lot better than just having a very formal them and us. I mentioned before about some of the drivers for some of these changes, and a very big driver is about the conduct of these companies. You'll have seen conduct rules, very, very, very current at the moment. Lloyd's of London subject to very detailed conduct requirements. And that has all fed in to these requirements. Ultimately, the regulators are interested in making sure that you, the insurers, and you, the intermediaries, are providing to your customer, the insureds, whether they're SMEs, whether they're retail customers, whether they're large reinsurers, as appropriate a service as possible in a fair and open way. And a lot of these rules are framed around trying to meet those conduct requirements. So, have an open dialogue with the regulators, have an open dialogue with your third-party outsourcers, but in the back of your mind, always remember you have to plan for the third party's failure. That's your responsibility, you have the obligation, it's your regulatory responsibility. They can go bust, you'll be the ones that are getting the final notice. What have we had today? RBS fine for the payment system meltdown. So yes, they'll have outsourced lots of their IT services, but that didn't absolve them from their responsibility. So as I say, have an open dialogue with your regulators, have an open dialogue with your outsourcer as well, but remember, if it goes wrong, it'll be your fault and no one else's. So on that very happy note, lawyers, we're always being accused of being a bit pessimistic, but we only see things when they go wrong, so you can understand why I've got that mindset. That was all I was going to say on the topic today. I've finished about 5 minutes early, just to leave time for any questions or just so that you can leave and stretch your legs. But I wanted to thank you for coming along. I'd be grateful for any feedback as well. Come and talk to me privately, because pitching this at the audience sometimes is interesting, which is why I asked you. So, but enjoy the rest of the next sessions. I've given you enough time to be able to get there, and thank you.